Hi everyone, and welcome to SA Mining Desk, your partner in navigating the South African mining sector. In our previous episode on the case file, we looked at the Anderson judgment. In that matter, a landowner, Anderson, sought a final interdict to stop Silver Unicorn from conducting mining activities on a portion of a farm bordering their property. The court refused the interdict, finding that Anderson had not met the requirements for a final interdict. If you missed that episode, be sure to check it out on our platform. Today, we're unpacking an important two-part judgment that brings much-needed clarity to the mining right application process. We're focusing on two key issues. One, the role and powers of the regional manager, RM, when accepting or rejecting mining right applications. And two, how the queuing system works, especially where a fully compliant application is affected by an administrative error. We're breaking down the High Court judgment in Labonte 5 and the follow-up appeal in the Supreme Court of Appeal in Sandhawks versus Labonte 5. Let's get into it. Labonte 5, Pty Ltd., applied for a mining right to mine sand on 23 July 2010. Their application covered several farms, including Ehrenbreitstein and Wanderboom Hoek in Limpopo. The regional manager for the Limpopo region accepted Labonte's application on 20 September 2010, but with a major mistake. He excluded those two farms. He believed incorrectly that Sungu Sungu Mining Company already held prospecting rights for the same mineral on those properties. This was an administrative error. About a year later, in August 2011, Sandhawks Pty Ltd. and Seacrest Investment 129 Pty Ltd. applied for mining permits on those same two excluded farms, and the RM accepted their applications. Labonte suddenly had competitors on properties they had originally applied for. They continued engaging with the department to resolve the issue. Eventually, following the department's advice, Labonte submitted a second application for the same farms in November 2011. On 3 April 2013, to protect their position, Labonte lodged an internal appeal to the DMRE. They appealed both the partial acceptance of their application and the RM's acceptance of the Sandhawks and Seacrest applications. On 6 May 2013, the RM wrote to Labonte confirming acceptance of their second application, explaining that there was no conflict with Sungu Sundu because Sungu Sungu had been prospecting for a different mineral. Then, on 14 March 2017, the Deputy Director General granted Labonte's mining right, including the two originally excluded farms. At this point, Labonte's internal appeal was still pending. On 12 April 2018, Sandhawks lodged its own internal appeal, this time challenging the RM's inclusion of the two farms in Labonte's application and the DDG's decision to grant the mining right. In December 2019, the Director General upheld Sandhawks' appeal but failed to deal with Labonte's earlier internal appeal. Labonte then took the matter on review to the High Court before Judge Fury, who delivered judgment on 11 August 2022. Labonte asked the court to review and set aside the DG's decision upholding Sandhawks' appeal, and declared the DG's failure to decide Labonte's internal appeal unlawful and grant appropriate relief. Only Sandhawks and Seacrest opposed the review. The key issues for the court to determine were whether the DG's 19 December 2019 decision was lawful. This required the court to consider whether the RM was Functus Officio after partially accepting Labonte's application or whether he could correct his error. Whether the DG irrationally or unreasonably condoned Sandhawks' late appeal. Whether the DG's failure to decide Labonte's internal appeal should be declared unlawful and replaced with a decision upholding their appeal. This included considering whether Labonte had abandoned or waived its internal appeal, and whether the DG's refusal to grant condonation for the late filing of Labonte's appeal was unreasonable. The High Court ruled in favor of Labonte. On Functus Officio, the court held that the RM's function under Section 22 of the Mineral and Petroleum Resources Development Act, MPRDA, this section deals with acceptance or rejection of mining right applications, is a preliminary and not a final decision. The RM's duty is to check or verify whether the required information is included in the application as prescribed, a mechanical function without discretion on the merits. The final decision to grant or refuse a mining right rests with the minister. Therefore, the RM was not functus officio when he initially partially accepted Labonte's application or when he later decided to include the disputed properties. This means the DG's conclusion that the RM was functus officio was an error of law. On administrative action, although preliminary, the RM's decisions, both the initial exclusion and the later inclusion of the farms, were administrative actions under the MPRDA and Promotion of Administrative Justice Act, PAJA, because they had the potential to affect rights and produce serious consequences. On condonation, Sandhawk's appeal, the DG did not consider all relevant factors, such as the length of the delay, the explanation for the delay, and prejudice to the other party in deciding to condone Sandhawk's appeal, and that the reason it will be in the interest of justice that the appeal be heard was insufficient. This failure was a material irregularity. On DG's failure to decide Labonte's appeal, the court found that the DG failed to consider and decide Labonte's internal appeal despite a statutory duty to do so. This failure was also declared unlawful. On exhaustion of internal remedies for Labonte, the court found exceptional circumstances to exempt Labonte from exhausting a potential further appeal to the minister. These reasons included the interrelated nature of the two appeals, the likely significant delays, and the complex legal question of functus officio. The court made a series of orders, including that the decision by the DG on the appeal of Sandy Hawks was declared unlawful and set aside. The failure of the DG to consider and take decision on Labonte's appeal was declared unlawful and set aside. The court remitted both internal appeals by Labonte and Sandy Hawks to the department for reconsideration. Sandhawks lodged an appeal against the judgment and order of the Gauteng Division of the High Court, Pretoria, to the Supreme Court of Appeal. The judgment was delivered on 16 August 2024. The issues to be determined whether the Director General's decision on 19 December 2019 related to an internal appeal lodged by Sandhawks should be declared unlawful and set aside. Whether the regional manager, RM, was functus officio, meaning had exhausted his authority, after partially accepting Labonte's mining right application, excluding the property in dispute, or if he could correct that decision later. Whether the DG irrationally and unreasonably condoned the late filing of Sandhawk's appeal. Sandhawk's argument contended for a strict queuing system under Section 9 of MPRDA. If an application is not accepted, even partially, it is rejected and terminated, and any resubmission is a new application at the back of the queue. They argued that Labonte's initial partial acceptance meant the property was excluded, and the RM was functus officio to later correct this. They also implied the DG was correct in upholding their appeal. Labonte's argument argued that its initial application was compliant with Section 22, and the RM's initial exclusion of the property was an error. The RM's role under Section 22 is clerical sorting and not a final discretionary decision, meaning he was not functus officio when he corrected his mistake. They contended that their application remained alive and held its place in the queue due to the RM's error and their continuous engagement with the department to resolve it. The Supreme Court of Appeal dismissed the appeal and found as follows. On functus officio, the court agreed with the High Court that the RM's decision to accept, or partially accept, an application under is not a final decision. The RM performs a clerical sorting role, checking for formal compliance. The decision is a preliminary step in a two-stage process, with the minister making the final decision to grant or refuse the mining right. Therefore, the RM was not functus officio and was entitled to correct his error. On condonation, the court found that the DG failed to properly apply his mind to the issue of condonation for Sandhawk's late appeal. The DG's reason to condone, in the interest of justice, was insufficient.
The DG did not consider relevant factors for condonation as established in Oricon South Africa Pty Ltd versus Cape Town City. These factors include the nature of the relief sought, the extent and cause of the delay, its effect on the administration of justice, the reasonableness of the explanation for the delay, the importance of the issues raised, and the prospects of success on review. This constituted a material irregularity and an error of law. On Section 9, queuing system, the court interpreted Section 9's different dates must be dealt with in order of receipt as a queuing system. However, it held that Labonte's application was compliant from the outset, and the RM's mistake should not cause Labonte to lose its place in the queue or be forced to resubmit as a new application. Labonte's application remained alive and held its place in the queue due to the RM's error and their continuous engagement with the department to resolve it. Administrative action and PAJA. The court affirmed that the RM's decisions are administrative actions subject to review under PAJA and Section 96 of the MPRDA, even if not considered final for the purpose of the Functus Officio doctrine.
This judgment clarifies the regional manager role in accepting or rejecting application. In so doing, the RM role is merely clerical and mechanical and does not constitute a final decision. He is therefore at liberty to correct errors in the decision. However, the decision remains an administrative decision under the MPRDA and PAJA. The final decision on application is the granting or refusal. Furthermore, an applicant whose compliant application was initially mishandled due to administrative error should not lose their place in the queue. Thank you for listening to SA Mining Desk, your partner in navigating the SA mining sector. On our next episode on the case file, we will be looking into the case of Platinum South Africa and Southern Sphere Platinum Pty Limited versus Samanco Chrome Pty Limited and others, where the coexistence of two mining rights by two separate entities where the geology of the area means chrome and PGM intermingled. It's gonna be mind-blowing. Till next time.